We shall begin with our very first feature, which is focused on health law. This is a presentation of Attorney Kenneth Haber from Boyd's, Maryland. The moderator here is Attorney Ramesh Khurana from the Khurana Law Firm located in Gaithersburg, Maryland. This morning, Attorney Haber addresses what to watch out for when a doctor attempts to make an honest dollar through concierge medicine. Let's join these two attorneys on this hot topic.
Welcome to the Capital Forum. This is Ramesh Khurana, attorney at law, having my office in Gaithersburg, Maryland. I have great pleasure in presenting to you a very knowledgeable and experienced attorney, Mr. Kenneth Haber. Mr. Haber, welcome to our studios.
Thank you, Ramesh. Thank you for the
Just for the
welcome.
purpose of introduction, thank you. Just for the purpose of introduction, Mr. Haber is a former assistant U.S. attorney and a senior attorney in the Office of Inspector General, and he has his office in Maryland, and some of the cases he works on with other local lawyers, local jurisdictions throughout the United States, especially in regard to medical cases. Physicians can be greatly benefited by engaging Mr. Haber's services.
Well, thank you, sir.
Thank you. And I know that certain outcomes have been excellent.
Oh,
And
thank you.
thank you for serving the community.
I appreciate
Yeah.
that. Thanks.
Today I'm going to ask you questions about physician and the National Practitioners Data Bank. I know that data bank is something which is of great importance to the practicing physicians. Now, can you please tell what is the National Practitioner Data Bank?
Yes, the National Practitioner Data Bank was set up by Congress because in the old days, a physician who was sanctioned by various entities could just jump jurisdiction, go to a different state, and it would be difficult to trace him and follow him and know what his background is. So Congress decided they're going to create a National Practitioners Data Bank, and that is a wonderful purpose. However, just as anything else, a well-intended purpose can often be misused, abused, and misapplied, and it has been. And for those who it has been misapplied, abused, and misused, it's a terrible draconian sword that can pierce their very professional existence and cause them to be set back to the point where they might need a different career even.
I agree with you. Yeah. Now, Ken, you have beautifully explained the objective as to why it was created. Now, my question is, who are the physicians or healthcare service providers who would be data banked?
Well, the way it's set up, there are reporting entities, and this is aside from government entities. It could be insurance companies, it could be hospitals, it could be professional societies. The main thing is, except for the insurance, malpractice insurance, there's a special part of the statute for that saying that if there's a payment made concerning a malpractice of yours, you got to be data bank, period. The question becomes in those circumstances
that obligation is on malpractice insurance carriers.
to report it.
Oh, I see.
But the difficulty is that sometimes they got their own interest into who they're going to report. And so that can be misused and abused. Associations, professional associations, if they have due process procedures, then they have to be considered reporting entities. So if they take away somebody's credentials, then because of some sort of improper action on the person's part, not just because he resigned or because he's a competitor of somebody, but because of some wrongdoing on his part, then they're supposed to report him. Hospitals, the same thing. If a doctor gets due process at a hospital and they find that he needs to be suspended over 14 days or he needs his privileges revoked, he's supposed to be reported. Hospitals, unfortunately, can have ulterior motives for doing this, just like any of these other associations. They're not supposed to, but anything that's set up with a good purpose can be misused, misapplied for an evil purpose, and that's what happens quite often. Doctors can be subjected to competition through the hospital because the hospitals lots of times have favorite doctors, either that they're employed by contractors or directly employed by the hospital, but the hospital has a vested interest in them, or maybe a sister hospital has an interest against that particular physician, and they can use this as an anti-competitive mechanism against that doctor by data banking him. And it doesn't just force him out of town, but it actually can cause him to lose his practice. And that's the difficulty in terms of data banking. It's supposed to be the way Congress thought it would be, is that there are these somehow pure institutions that only are motivated from the best of interest, and that they're only going to come to a fair decision on whether somebody did something wrong or not, and that this pure institution should then report that person who they found to have done something wrong. And this is not a pure world.
Right.
And, you know, institutions are made of human beings, and they are often corrupt, and the process can be corrupted.
Now, Ken, what I understand from your comments is that intent of the Congress was not to make it mandatory, rather it was to be left to the discretion of associations. And likewise, you stated about the malpractice insurance carriers, like sometimes they do, sometimes they don't do. Do they have any sound discretionary authority to make a decision?
They have discretion in terms of going through their processes, but they're, you know, how their processes turns out can be very arbitrary. You know, if they charge somebody with some wrongdoing, and maybe a favorite doctor doesn't get charged, but a doctor who's not favorite, you know, maybe does get charged. And maybe that what they do is put on the peer review committee people who are hostile to the particular doctor who's being charged. So there's all sorts of ways that the system can be manipulated. And the insurance companies, they may not want to say that it was the hospital's fault, because they may be insuring that hospital for a large sum of money. So they may want to say that it's the doctor, a particular doctor's fault that there's a payment. So, I mean, they're not supposed to. They're supposed to be pure, but they're not pure. They're institutions, and institutions, like I said, are composed of individuals, and they can be as corrupt as any political system can be corrupt.
So that depends upon the evaluation process in place by the malpractice insurance carrier. Is that correct?
Yes, and it can be manipulated.
Right.
Yeah, it's.
So there's a subjectivity involved.
There's a subjectivity. It's supposed to be objective,
Right.
just as the due process procedures are supposed to be objective, but they're often subjective, and purposes, bad purposes come in there. And indeed, under the Healthcare Quality Improvement Act, if there are bad purposes that are involved, if they're not doing things properly, they don't get the immunity that is part and parcel of that whole statutory framework that Congress established. But it's an uphill battle that a doctor has to fight to show that there's improper purposes that are being employed, or that are employing these mechanisms.
So, Ken, I do understand. Now, let us say mistakes do happen in professional practice, whether it's a lawyer or a doctor or any other medical service provider. But the question here is, once a physician is data banked, his name has been entered in data bank, of course he's stuck with that kind of adversarial record, I think, forever. right? Or does it go away, or you can expunge those records? Is there any mechanism?
Well, there's a mechanism that the doctor is supposed to be able to put his side of the story in. But, but often that doesn't help. People will see, oh, there was this or this or this that happened. And depending upon the demographics of the area, it may or may not have a devastating impact upon the doctor. If he's the only OBGYN in the county, you know,
People don't have any options.
people have no options.
Right,
Exactly,
right,
exactly.
right.
The fact of the matter is demographics really do have a significant impact in terms of how it's going to affect, you know, any particular doctor, this data banking. But if he's in the metropolitan area, it might very well turn out that the insurance company that insures for malpractice doesn't want to see him no matter how much he's going to pay. The insurance companies that pay third-party payments, you know, like Blue Cross, don't want to deal with him. And, you know, his career can be sunk by improper data banking. The question becomes, what does a good doctor do
Yes.
when he's improperly data banked? Or what does a good doctor do when he's properly data banked for a single mistake, you know?
Right.
You know, if he's improperly data banked, he's got more mechanisms to protect himself because of the fact that if he can show that there's an improper data banking, you know, he can do one of several things. One is he can put his side of the story into the record, which usually doesn't help much.
It is just for his emotional satisfaction.
His emotional
that I
satisfaction.
did justify.
If he's got enough evidence, he can present it to the data bank and try to get them to correct the wrongful entry under the Privacy Act. The data bank does not want to recognize the Privacy Act, but we've had them recognize the Privacy Act twice. And on a third occasion, when the government data banked client of ours, we sued the government. They were excluding him, and we felt the exclusion was improper. That's another way of doing it. Sue whoever's put you in the data bank, and we sued the government and enjoined the government from excluding this individual. So one way is by writing a Privacy Act request for correction. If that doesn't work, then suing the data bank under the Privacy Act and having hopefully the judge agree with you. And the third way is to sue whoever data banked you. In our situation, in that particular case, and we've had all three mechanisms work for us. In that particular case, the government did withdraw the exclusion, and not only withdrew the exclusion, took the data banking out retroactively and the exclusion out retroactively. But then, of course, they left the data bank in. He was excluded, but retroactively reinstated because they were trying to put a finger in my eye because the judge put a finger in their eye because they were hoping the judge would just clear the record of the injunction we got. And the judge didn't. He just put down vacated for other reasons, and it's still in the books. So they were a little upset.
I'm very happy to know that we have here a very knowledgeable and experienced attorney who knows how to help physicians if they are data banked improperly, at least. You know, thank you so much. I think we are running out of time, and I must appreciate your coming to our studios and talking about this very, very important topic, which is of great significance. I'm pretty sure our audience has enjoyed it. I appreciate your coming.
And I would certainly recommend to the viewing audience, if you have a problem in this area, get a hold of a competent healthcare attorney who has the experience of doing these type of things.
Thank you.